Hello everyone, welcome to the course on advanced contracts. We will start the course by understanding the course content. And as you see, this course is going to be offered for 12 weeks. And the week-wise plan on dealing and understanding contracts is something like this. In the first week, we'll try and understand the basics of contract law. We know that there are contracts that we do in our everyday lives. Some are implied, some are expressed. When we say implied contracts, it could mean the newspaper that is being delivered to you early in the morning along with the milk that comes to your door. You may be taking public transport or an Ola or Uber. You may be getting into employment contracts because you're employed, or you may be dealing with commercial contracts on the sale or purchase of property as well. So we'll try and understand what it takes to understand the law in relation to contract. What does the law say? And hence a basic introduction to Indian Contract Act 1872 will be something that would be attempted in week 1. In week 2, we will go into the essential conditions of a valid contract. That includes an offer, acceptance, capacity, consideration, and free consent. Without these, you will notice that the contract will not be enforceable at law. So we'll try and understand them in a modern context, in a sense how in today's times these conditions of a valid contract are important. In week 3, we will go to unfair terms in contracts, as we know that this is a major problem in today's world, especially which has globalization and privatization. Contracts are used to exploit sometimes the other party. We have seen why there is a necessity of getting a consumer protection law so that consumers are protected from some of these unfair terms in contracts. We'll try and understand the difference between void and voidable contracts. But most importantly, I think in week 3, we will try and look at public policy and how the courts can intervene on the grounds of public policy to hold a contract as being void. This is also part of the entire course because we'll be talking about, say, clauses like non-compete clause, confidentiality clauses, employment bonds, and so on and so forth. You will also notice that it is important for us to understand the mechanisms in which the contract has to be performed and what are the conditions for discharge of contract. So these will also be covered along with the aspects of quasi-contracts as well. When we come to week 4, we will try and look at remedies for breach of contract. You will notice that there are different remedies and hence the aspects on Specific Relief Act, which was also amended in 2018 to bring in a very interesting remedy called substituted performance will be discussed along with the law on damages. Week 5, we will get into special contracts because after having laid the first 4 weeks on the foundations of contract law, which is a valid, which is avoidable, which is void contract, what are the remedies that parties have, then we move on to understanding what are special contracts. Now you will notice that the Indian Contract Act 1872 lays down the basic principles of the rights and obligations of parties in special contracts. We have contracts such as agency contract, which is also called as representative contract. We have indemnity and guarantee. Then week 6, we can go to bailment, pledge, lease and hire purchase. And then we can go to sale of goods and partnership in the following weeks as well. Week 8 is where we will branch out to understanding some of the modern forms of contract. For example, we will try and evaluate whether a student-university relationship can be governed under contract law, as is being done in the United Kingdom currently as of now. We will also try and understand electronic contracts because we understand right now that with the passing of the Information Technology Act, electronic contract is also doable. We know e-commerce is catching up. We know that there are a lot of consumer contracts online. There can be business contracts online. We have moved from a physical signature to electronic signature. All of those aspects, I think, we'll try and analyze in week 8. We'll also look at some of the aspects on introducing you to escrow agreements. These are special types of agreements that is now being created, which is very close to an agency contract as well. Now, the last 4 weeks, friends, will be on government tendering and procurement. So, this is the combination that we thought will be relevant for this course. And hence, we will start with government contracts. You know that the Constitution of India does define the aspects that are required for an enforcement of a government contract under Article 299. You will also notice that it is government contracts kind of assumes a major part of contracting and business in this country. And there are so many tenders floated, public procurement is being done, there is privatization of government businesses, and hence this is a unique opportunity to understand the law on government contracts. We will try and look at the constitutional basis. We'll look at the issues on transparency and accountability. We'll look at competitive pricing and why tender is a law and when can tender be avoided. We should look at some of the pre-tendering processes, how to evaluate tender bids, how to determine L1, H1, what is the difference between a letter of intent and an MOU, how to issue work orders, and we'll also look at CVC, that is Central Vigilance Commission, and the CAG, that is Comptroller and Auditor General of India guidelines on public procurement. I think this will definitely bring in a lot of practical aspects in the course where we will try and look at, what are the aspects of negotiation? What are the aspects of drafting a contract? How do we look at evaluating certain clauses in a contract? I think a very practical hands-on approach will be adopted in the advanced weeks, so that the students are not only getting an experience of theory of contract law, but they will also probably get into some of the practice and the interpretation and construction of contract law. So that's how this course is titled as Advanced Contract Law. I think, we will look at, say, specific clauses, for example, looking at evaluating a force majeure clause. What has been the Supreme Court guidelines on force majeure, especially after the COVID pandemic? The force majeure clause has been a very important critical clause in most contracts. And you will notice that Section 56 of the Indian Contract Act talks about the law of impossibility of performance. Now, you have to probably compare impossibility of law in contract to force majeure. And is there a difference between the same? Judicial review of government contracts will also be a critical factor, because you know that a writ can be filed to check unfairness in government contracting, both in the procedural sense, also in the substantive sense, and hence those cases give us a kind of a view of how the courts try and scrutinize some of these contracts, because there is public money that is involved in making government contracting. In the last week, we should get into dispute resolution. We should look at arbitration as an alternate form of dispute resolution. Let me also state here, though you would not be seeing in the slide over there, that it would be relevant and important for all of us to look at aspects of the commercial code, which is now being established to handle disputes in contracts. So we will try and understand Commercial Code Act, dispute resolution through arbitration, disputes in the courts, and we will try and look at aspects of confidentiality, intellectual property protection, data protection in government contracts as a specific issue as well. So in this 12 weeks course, friends, what we attempt to do is we would want this course to be useful for practitioners, those who are actually executing, implementing, negotiating contracts for organizations. So this course will be useful to government officers. It will be useful for managers, leaders in organizations who would want to have an insight into understanding of contract law, in understanding the practicalities of contract law, and to ensure that their contracts make a business profitability, their contracts are legally tenable, their contracts don't run into disputes. And we hope that this course will have a learning outcome which can be taken forward in organizations to actually strengthen contracts in each individual as well as an institutional sphere. So welcome to the course, and in the next part of this, we should start with week 1 in understanding the basics of contract as we go forward.